Make this carnival a special one at Spice Isle Jewelry. Get up to 40% off our collection of silver and gold jewelry with purchases above $115. Visit our 2 locations on Grenville Street, St. George's and Spiceland Mall, Grand Anse, and see our fine selection of traditional West Indian bangles, necklaces, earrings, rings, and our unique handmade pieces. Step into Spice Isle Jewelry and shop in air-conditioned comfort with friendly, helpful, and courteous staff. We also pay the most for scrap gold. Our repair service is second to none. Treat yourself or someone special with something special from Spice Isle Jewelry, serving you since 1986. Call us on telephone number 440-3155 or 440-6648. Sale ends August 31st.
Check. Yeah. Check. Yeah, I guess you guys wasn't hearing me, huh? Hope you guys hear me now. Yeah? 1, 2. Everybody hear me good? Everybody hear me good? Give me a thumbs up if you hear me good. Give me a thumbs up if you hear me good. If you hear me good now, give me a thumbs up. I was just testing your guys' ears now. I just want to make sure all your ears clean. I just wanted to make sure all you could hear. Riders. Yeah, all right. Everybody good? As you come and share everything. Pat, Maria, Susan, Kibbs, how you doing? Yeah. Thumbs up. Thank you. So guys, I was saying, for this past week or so, there have been so much information that circulated, especially legal information. And what prompted this particular program are 2 things, right? I saw a post, guys. We made a post, and I saw some comments under that post, and I said to myself, they need more clarification, or we need to apply a little more clarification on the law as it relates to civil and criminal. And also, someone asked a question. People asked the question about the speed in which a case gets circulated, right? And how priorities are set in court, So we decided to bring on the legal expert. You know him, he's been on the program before. Mr. Ruggles Ferguson, he's no stranger to the program, guys. This man is an encyclopedia in person. He just has it right here. Best person to bring us up to speed on this, guys. Yes. So as you guys come and go ahead and share up the thing, let me do that on my end as well. Valette, how you doing? Wendy Charles, thank you so much. Let me share.
That's my end as well.
Yeah, okay. I know I'm hearing myself. Yes. Okay, share a couple times. Share here. Nakisha Allen, thank you so much. Now listen, all you have to share the program more than once, you know. Yeah, all you have to share the program more than once. This is too important. Hey, Pat, how you doing? This is too important for most people not to catch up and see and hear what we're speaking about. So I'm going to share it at least 3 times. Is that important? Yeah. Okay. Hold on. One more time. This one is for good luck. All right, there we go. Okay, guys. So let's get right into it now and bring on Mr. Ruggles Ferguson. Again, he is no stranger to Ridealong Live. Mr. Ruggles Ferguson, my brother, how are you doing? We're not hearing you.
Yes. Hi, Junior. Are you hearing me now?
I'm hearing you perfectly.
Yes.
No, perfectly fine.
Yes. Hi. Good evening, and good evening to your listeners and viewers.
Yes. Absolutely. Ruggles, how you been? I was in Grenada for 2 weeks and I ain't see you. I don't know if Ruggles in a special part of Grenada. I ain't see you at all.
No, well, you would not have seen me because I was out for about 2.5 weeks. I had meetings outside, in fact, in Chicago.
Okay.
And only returned on Sunday evening.
Okay.
So I was out probably about 16, 17 days.
Oh, so that's why
you didn't see me. Yes.
I saw everybody else and passing and I said, Grenada is not that big. At least if I'm in Grenada, I'm supposed to see Ruggles because he lives somewhere over here.
Indeed. I just happened to have duty called elsewhere.
Yeah, I hear that. Ruggles, as I was saying at the introduction, right? I find that it was important to have this conversation based on a post that was published on our website, and two very important things I want to discuss. There will be more, but top priority, 2 most important things. Let's start with it, right? I want us to in this recently concluded criminal case between in the Anderson Peters and the Harbor Master case. There were a conclusion based on the judge's conclusion, and he ruled that there was a fine that was supposed to be paid, and that fine would be paid forthwith. And if he was not paid, then there is a 1-year jail sentence. I want you to break it down for us so we could understand it, because a lot of clarification still need to be had as far as with the verdict the conclusion on the verdict that was handed down by Teddy St. Louis. So just break it down a little bit about the verdict.
Okay, so break down. Well, first of all, maybe it will be useful to first of all put in context one, the division of matters in court. Generally, they can be broadly, for simplicity's sake, categorized as civil matters,
yes,
and criminal matters.
Right.
Civil matters and criminal matters. That's the first thing. Secondly, when you address criminal matters, there are 2 broad categories under which criminal matters fall. And they are what you call indictable matters, and there are summary matters. Indictable matters are the most serious matters. And the main distinction, in a sense, is that summary matters can be heard and determined in the magistrate's court.
Right.
In other words, the magistrate can find you guilty or not guilty. The matter comes before the magistrate. The magistrate conducts a trial. if the person pleads not guilty and the magistrate hands down a verdict. That's summary matters.
Right.
For indictable matters, the magistrate will conduct not a trial, but is what is called a preliminary inquiry
Right.
to determine whether or not there is sufficient evidence to send the matter up to the High Court for trial before judge and jury.
Right.
So indictable matters are tried before judge and jury.
Mhm.
Summary matters are tried before a magistrate.
Right.
So it is important to understand that what just happened in relation to the Anderson Peters matter is that the criminal matter was heard and determined.
Right.
And because the charges brought were what you call summary charges, then in those circumstances, the magistrate can hear and determine the matter.
Right.
Right?
Before
So
we go
that's
on
the
to question
first.
handed, I'm happy that you made that clarification, because the question now arrived about the charges, because initially people was questioning about the particular charge, and the fact that they saw someone push an individual into the water, that might mean that there should be a charge of attempted murder. Why there was no charge of attempted murder in this case?
Right. Well, each case is determined on its own facts and circumstances. I'm not au fait with the actual, apart from the media reports and of course discussions with persons on all sides who would have been involved in the matter. Based on the evidence, it was felt that the proper charge to lay was causing grievous harm. Now, let me just indicate too that in determining what the charge should be, it is especially when it relates to matters involving harm.
Right.
Then it depends a lot on the medical reports. So it starts off, for example, with a matter. I'm talking about a matter that can be an assault, for example. An assault doesn't necessarily require contact. You can assault somebody by simply coming into their physical space, pointing fingers in the face in a threatening manner, putting them in fear of some imminent attack.
Right.
Then you go to the contact aspects of it, which is the contact aspects of it, which involves now wounding. You can have wounding, you can have causing harm. All of these are different degrees. Wounding, causing harm, causing grievous harm, maiming. Maiming involves the loss of a limb, or for example, if part of your ear cut off or you lose part of your finger. That falls into the category of maiming. You have dangerous harm, you have attempted murder, you have murder, different degrees.
Right.
So when somebody comes in with a complaint, what the police would usually do is to issue a medical form. And that medical form will be sent to the doctor. And on the medical form itself, the doctor will tick off based on the injury under what category it falls. Because that is, all of these things are based on evidence. And in this case, the extent and the nature and extent of your injury depends on what the doctor says is the injury. And the doctor will tick off, for example, wound, causing harm, causing grievous harm, maiming, dangerous harm. Obviously, in this instance, more likely than not, the causing grievous harm because of the nature of the injuries. The grievous harm was ticked off. So in charging anybody, the police, for example, are not experts in medical issues. The prosecution by themselves are not experts in medical issues. And that's why what the doctor says, and how the doctor categorizes the injury, then that would inform the charge.
Okay.
Because then if you bring another charge, then it can be challenged based on what the medical evidence actually shows.
Right. So, but let's look at this case here in particular. The medical evidence would show that there was some grievous harm, but there was also a point in the physical contact where said person fell into the sea or was pushed into the sea. Would that medical report would that be on that medical report, or then it would be, or the prosecutor would then have to look at the occurrence to insert that into the charge because he was pushed into the sea.
Right. The latter, whatever the doctor's report is based primarily on what his or her physical examination shows. The doctor would not get involved in the actual surrounding circumstances. That is a matter for the prosecution, piecing together, one, the actual harm,
right,
and two, the circumstances that led to the actual harm. So so that's where it depends on that. So in these circumstances, whatever the circumstances and the evidence in the possession of the prosecution, in their wisdom and judgment, they determined that the proper charge to bring was causing grievous harm.
Right, and no prosecutor would go in or put a charge that they know they can't prove. Like they have to at least have the bar set. Like they won't put attempted murder and try to go through the attempted murder if they don't have enough evidence to back up the attempted murder charge. Because if they fail on the attempted murder, then the person could just walk free because there's no other charges.
Precisely. So in other words, it depends on it all depends on the evidence. What that evidence is, because remember, laying a charge is simply the first step. At the end of the day, when you come to court now, you have to establish. And in criminal charges, for criminal matters, the onus is on the prosecution to prove the case. A defendant can simply go to the court and say nothing, because he has nothing to prove. He can disprove, but the onus is on the prosecution to bring the case, to prove the case against the accused. So the prosecution has to be very careful, very cautious, because everything can fall down if it's not supported evidentially.
Right, and it's important because we had another lawyer on the program here, and he was making the same point that it's important that you examine the charges and if you have the evidence to back up those charges. So I'm happy that we bring it up, and we're speaking here, guys, again with Attorney Ruggles Ferguson. And the first aspect that we're speaking about is the criminal. But there's another aspect, as Ruggles said earlier, to this case, which is the civil, and we're going to talk about that a little bit later. We also open up the phone line, guys. The number is on the screen if you want to call in to ask any questions, or if you have anything that you want to insert, you could call in. The number again, 718-701-5720. Now, in the case of Anderson Peters' criminal case, causing grievous harm, what does the prosecution have to prove? I want you to, if you say it, I want you to give a clarification again. What exactly that they have to prove? Is it that they made the contact? Is it that it was an antagonizing situation? What is the proof the burden of proof for the prosecution in this case?
Okay. So, in fact, let me approach it from your last statement, burden of proof, because that is an actual feature that has to be proven. As I said, first of all, the onus is on the prosecution to prove the case. So first principle, an accused can go in a court and say nothing.
Right.
He doesn't have to contribute to or assist the prosecution in establishing the case against him or her.
Right.
So the prosecution has to prove the case, and that is what is really burden of proof. The burden of proof is on the prosecution to prove the case against the accused. So that's one principle. Second principle, as a concept, you have standard of proof. So you have burden of proof and you have standard of proof. And the standard of proof in criminal matters is beyond reasonable doubt. So, and beyond reasonable doubt means that you must be sure after hearing the evidence of the guilt of the accused. So that's the standard. The standard in civil matters is slightly different because in civil matters, the standard is on a balance of probability, which is a lower standard. But the criminal standard is a higher standard, and that is beyond reasonable doubt. So you have burden of proof and you have standard of proof. The two other important concepts are one, and those are just the technical names, the mens rea, one, and two, the actus rea. Actus reus. What the actus reus means is that the act itself. So the actus reus answers the question, did A cause harm to B? So if, for example, is a stabbing, is a shooting, is a big stone, whatever, did A stab B? Did A shoot B? Did A stone B and injure him?
Right.
So if the answer is yes, that answers the question that the act was caused by B. Now, secondly, the other element that has to be proven in a criminal matter is that the mens rea, which means the intention,
Right.
was the act. And in other words, okay, did the person pelt a stone and it hit B, but it was really intended for C as some act of self-defense as to what C was doing. In other words, was it an accident or was it deliberate?
Yes.
Right? These are factors because you can have the act being done.
Right.
But the act can be justified in law as being one in self-defense. Yes, I did it, but I did it in self-defense.
What if the act is provoked or is said to be provoked or could be established was a provocation on B? So A had some kind of provocation on B, B did something to A, and that's what happened. What consideration is taken then?
Okay, important question too. And different concepts. So let us contrast, for example, self-defense.
Right.
As opposed to provocation. Self-defense is a complete defense because an individual has a right to defend himself from an attack. And in doing so must use reasonable force. Provocation, however, is not a complete defense. Provocation is what is called a mitigating factor. A mitigating factor. And so it does not offer a defense. It puts the incident in context and is more important. Let's say in the case of murder, right? In the case of murder, provocation reduces the offense of murder to manslaughter.
Oh,
but it is not a complete defense.
It's not a complete defense.
Right. And provocation is used in not in establishing liability, because you can be liable even though provoked. You can be liable. However, in sentencing, the issue of provocation will be taken into account in sentencing, but not in determining a person's liability.
Right.
And the contrast, well, as I just explained, in murder cases, there is a particular unique feature because it reduces the offense of murder to manslaughter. So, for example, somebody has to be charged. There's a killing and somebody has to be charged. And based on the circumstances of the killing, there was provocation, and provocation has to meet the test of law.
Right.
Not just anything is a provocation. It must meet the test of law. That someone was provoked to the extent that he or she lost his or her self-control, and was not master of his mind at the moment that the act was conducted. So even the law defines what is provocation. Provocation in speaking just as a manner of speaking versus provocation as a legal concept. These are two different issues. But it is taken into account, like in charges like these, when sentencing.
Right.
Okay, the person is guilty, but let's examine the circumstances, whether there are any mitigating factors that can go in favor of the person.
What about the use of force, right? And the use of equal force. If someone were in self-defense or provoked to the point, and based on the provocation or based on the self-defense, they then get a group of people to assist in the defense, or they use more force, or they use a baseball bat, or they use a hammer or whatever. Could that be used as a self-defense in court?
Right. Well, again, it depends on the circumstances and how you have phrased the question.
Mm-hmm.
In other words, in defending oneself, one must use no more force than is reasonably necessary.
Right.
In the circumstances. So, for example, if somebody is attacking you and you manage to overpower that person and you knock that person cold out on the ground and the person is lying on the ground, right?
Mm-hmm.
Good up to there. Now, if after the person obviously is not in a position to continue the attack and you stamp the person on the head,
mm-hmm.
then that is going beyond what is reasonably necessary. In other words, the principle of proportionality, that somebody attack you with a fist, for example, and then you pull out a gun and just shoot them, right? Yes, you were attacked, but is the force proportional to to the attack, right? Is your self-defense, and that's where the different the fine lines, in other words, the fine lines come into play.
Right. So we saw in the same video here, we're talking about in the criminal case, we have Anderson Peters was attacked and his brother Keaton Peters was attacked. But we had Anderson Peters, they being charged for grievous harm for Anderson Peters, but only harm for Keaton Peters. What is the differentiation if you get into a brawl? How do you know who was grievously harmed and who was just harmed?
It goes back to the medical report, Junior. It depends on the nature. So, for example, in relation to Anderson Peters, I was advised among the injuries that he may have suffered would have been torn ligaments in the region of his ankle. There are some issues with the cheekbone and so.
Okay.
So it's all a nature of injury.
Okay.
Matter. If, for example, there was the loss of a finger, and I'm just using this as an arbitrary example to illustrate the point. If there was the loss of a finger or a piece of a finger, that would have been maiming, right? Mm-hmm. The charge would have been different in those circumstances. So it all depends now on what the actual injury is, or injury or injuries.
Right.
So what it says on the face of it would have been the fact that one was charged with causing harm and one was charged with causing grievous harm, it means that the other person was not injured as seriously based on degree, no, purely on degree. To the causing harm guy, the Peter's brother, would not have been injured to the extent of categorizing it as causing grievous harm.
Okay, good information, excellent information. I myself learning a lot, and I hope people are taking advantage of this information here as well. Let's look at the sentencing guidelines now in the criminal case, right? People were very upset that, and when they look at it, like, how come they only charge this man $3,500, and what $3,500 could do, and only $2,500 for kidding. What $2,500 in all they were paid $5,500 per person. What is the sentencing guideline, and explain the sentencing guidelines for us, and what does the judge have to what does the judge have to stay, the margin that the judge has to stay within in order to sentence in case of grievous harm and harm?
Okay, well, broadly speaking, in terms of sentencing, no, that falls under a different regime now. So the first one is, are you guilty or not guilty? And maybe it might be useful at this point, based on part of the focus of the program, to say, because the accused pleaded guilty, there was no need for a trial.
Right.
So once you plead guilty, then the next stage is sentencing. If you plead not guilty, the next stage is a trial. And at the end of the trial, the magistrate or judicial officer, in this case, a magistrate, determines, after hearing all of the evidence, whether you are guilty or not guilty. If you are not guilty, then you are free to go. You are discharged. If you are guilty, then it goes to sentencing. So a guilty plea or finding of guilt by the court always leads to the next stage now, which is sentencing. And in sentencing, maybe to make it as simple as possible, one, a court considers certain factors. And in this case, we have sentencing guidelines, which were only introduced in 2019, 2020, for several different offenses, sexual offenses, murder, causing harm, and so. Now, the starting point one has to understand, in criminal matters, when there is a charge, one has to understand whether it's a summary charge or an indictable charge.
Right.
As I indicated earlier, but secondly, and very importantly, the law sets out what is the maximum sentence if the person is found guilty. Right? So in this case, causing grievous harm attracts a maximum 5-year sentence and a maximum fine of $5,000.
Right.
So that, those are the measuring rods.
Right.
$5,000. In other words, the magistrate can fine more than $5,000 because he is restricted by the law as to how much he can fine.
Right.
So $5,000 is the maximum fine. 5 years in prison is the maximum prison sentence.
And that's based on his discretion. That's based on just him deciding whether he want to give jail time or fine or both.
Well, it's not so much of a discretion now because of sentencing guidelines.
Right. But
you have actual guidelines where and how you apply the guidelines. But to put it probably broadly, and avoid getting into too many technicalities,
Right.
The what a court looks at is what you call the mitigating and the aggravating circumstances. They would weigh the two, the mitigating and the aggravating circumstances. What are those? What do those concepts mean? In mitigating, the mitigating circumstances are those that are favorable to the accused person.
Right.
The aggravating circumstances would be those that go against the accused person. So, for example, the issue as to someone being thrown into the water, that's an aggravating circumstance. So, for example, if and just to use a contrasting mitigating with those same facts, somebody falls to the ground and immediately the attacker seeks to assist that person or to get assistance immediately. That's a mitigating factor.
Right. Okay. Okay.
Right? So yes, the act is done, but what happens before and what happens after
right
are all taken into account.
I got you.
So and it is important too in understanding context. So first of all, the starting point is that the maximum sentence is one that the court cannot go behind, right? Above
right
that sentence. So the magistrate's hands are tied with one as to a prison sentence that can be imposed or a fine that can be imposed because the law lays it down. Secondly, maximum is maximum. It doesn't mean when somebody is found guilty, then the maximum will be applied.
Right.
There is what you call the nominal sentence. Nominal sentence. In other words, if based on this case, if this person is found guilty, what will be the starting point of the sentence? Would it be 3 years, for example? Because remember, the 5 years is a maximum.
Right.
And in applying the sentencing guidelines, what a court will do then is when you have that nominal sentence, especially if a custodial sentence is considered, you may start off with that, and then you consider the mitigating factors and the aggravating factors. With the mitigating factors, the sentence is reduced. With the aggravating factors, it will be increased.
So the mitigating factor in this case here could possibly be also the fact that he did not allow the case to go through trial and waste the court's time. And then so they get some time credit for that.
Not another get some time, but the law. So for example, someone gets credit, and you hear all over the world there's this principle called plea bargaining.
Yes.
Right? Plea bargaining. There's always plea bargaining. And when you plea bargain, is part of trying to ensure that the sentence is as low as possible.
Right.
So, for example, if an accused pleads guilty at the first opportunity, in law, he or she is entitled in law to a reduction automatically of 1/3 of the sentence. Automatically. Right? You are entitled, it's a legal entitlement because you would not have wasted the court's time.
Yes.
So for example, you can have a situation where two people involved in the same incident.
Yes.
These two people are charged for the same offense.
Right.
One decides to plead guilty the other decides to plead not guilty and go to trial,
Right.
and eventually is found guilty,
Yes.
the sentence handing down on these two individuals would be different. The one who goes to, even though it's the same offense,
Yes.
the one who went to trial and was found guilty would receive a higher sentence than the one who pleaded guilty at the beginning for the
Right.
same offense.
Well, hear this. Stick a pin right there. In this particular case here, we had one individual, Benjamin, Abiola Benjamin. He pleaded not guilty, but the charges was withdrawn. All charges was withdrawn from him. Was it a matter of he after doing the investigation they figure out something new? Because he was initially charged. When he went into court, he pleaded not guilty and the charges was dropped.
Yeah, well, that is not uncommon, and because it could only, because when you plead not guilty, a trial follows.
Right.
Right. So him being discharged or the charges being dropped, and I don't know all the inner intricacies.
Right.
Well, I'm just saying here, speaking of general principle. So generally, somebody pleads not guilty, then it goes to trial. However, in a situation where you have several individuals charged, it is not uncommon that as part of the plea bargaining process, you if one or two of the others agree to plead guilty, then as part of plea bargaining, then the prosecution would not pursue the charges against the others. So the only reason why there could have been a discharge of the individual is not that because he pleaded not guilty, but because the prosecution decided not to offer any evidence against him on the basis that the others decided to plead guilty.
Right.
Right? It's all part of a plea bargaining process.
Plea bargaining. Okay. Our next question here, guys. Listen, this is great information because, as I said, we saw so many comments and people taking the whole process way out of context. And I really wanted to have this discussion here with a legal expert. And I'm happy Mr. Ruggles Ferguson took the last minute time that we called him just a few minutes ago, and he decided to do this. So I'm really appreciative of this, to give education to the legal process. So again, Mr. Ruggles, we really appreciate it. Now, in the criminal case, in this criminal case here, the four individual was fined $5,500, and after that point, they was then able to leave. Where does that $5,500 go? Who gets that? Who gets that money? Is it Anderson get that money, or the court gets that money?
Right. Yes, an important question that usually creates confusion. No, when you are fined, right? When you are fined, that money goes to the state, right? That money goes to the state. A court has the authority to award compensation to. So, for example, for any criminal charge, especially summary charges, there are a range of sentencing options, including imprisonment, including fines, including compensation, including bond, reprimanded and discharged, a host of them. But when you are fined, it goes to the state. If you are awarded compensation, it goes to the individual. But in these circumstances, more likely than not, the virtual complainant, in this case Anderson, would not have wished to accept compensation because he has a separate civil matter pending before the court. And that's why I started off by saying that the law is divided into two broad areas.
Yes.
It's much more integrate it's much more intricate than that, but I'm just for simplicity's sake.
Yeah.
Say civil and criminal. And in this case, when a criminal charge is laid, it's an offense, it's in relation to offense against the state. So for example, if you look at the charge sheets, in this matter, the charge sheet will show Commissioner of Police versus A, B, C, the accused names, not Anderson Peters.
Right.
Anderson Peters in the criminal matter would have been the Anderson Peters would have been the virtual complainant. So he's merely a witness in the criminal matter.
Right.
Right? Because the criminal matter is brought by the Commissioner of Police for an offense against the state.
Right.
However, in the civil matter, it is his private matter against the individual. He can discontinue it, determine what in a settlement, what he wishes to accept. And in the civil matter, he's seeking compensation for his injuries.
Right. So
that's why most likely compensation would not have been considered in this matter. Because there's a separate civil matter pending.
So being a virtual complainant in this particular matter here, he doesn't even have to be there necessarily. He's a virtual complainant. Does he necessarily be in court?
Well, not necessarily, unless he wishes to make an intervention or he has to give evidence. If he has to give evidence, then he has to be in court.
Right.
But because there were guilty pleas, there was no need for him necessarily to be in the court. He could have been excused from being present in the court.
Right.
Because when there is a guilty plea and there is no evidence, what the prosecution simply does is to read the facts based on the investigations, read the facts before the court. The prosecutor gives those facts. The virtual complainant does not necessarily have to be there, neither the witnesses. They don't have to go in the box and give evidence. In contrast with a trial, if there was a trial, then the witnesses will have to go in the box to give evidence in the course of the court being able to determine whether or not the accused are guilty or not.
In the trial, I was trying to pull up the exact quote, but during the sentencing on Wednesday, the magistrate, Teddy St. Louis, said something to the effect, and I'm not quoting right now, he said something to the effect that where is Anderson? He was absent from there. So it kind of people was asking the question, well, if Anderson knew he had to be there, why wasn't he not there? Because the judge, the magistrate actually asked for him.
Right. And it's always, and this is just a personal view. Because of the nature of the case.
Right.
It's the court would have loved to have him there. I would think it's not that it is necessary for the court to conduct his business that he be there. But sometimes in sentencing, there is something called the victim impact statement.
Right.
And even at times the victim or the virtual complainant might wish to say something. And the court takes that into consideration in sentencing. If you are not there, then there is nothing said and the court does not necessarily take your view, or the court is not given the opportunity to hear from you. So I suppose it is in that context that the statement was made. Not that it was necessary for him to be there, but more so it would have been good for him to have been there.
Okay. All right. I want to talk a little bit about the civil case because, again, there is a big misunderstanding about what transpired as it relates to the boat. Now, the boat is now docked at Port St. George, right at outside of the port right there. And it's been there since the lawyer representing Anderson, Mr. Derek Sylvester, had a notice that was attached to this, so the boat can't move. Seizure notice, so the boat cannot move. But it is important to note that has nothing to do with the criminal case. That is for and as relating to the civil case. So even if the guys and them were fined and they paid a fine, the boat is still arrested. The boat is still docked until they work out the resolution between the civil case to release the boat. Right?
Those are two completely different cases. In this case, the aim of the criminal law is to punish. The aim of the civil law is to compensate.
Right.
So we issued the matter with the seizure of the boat. In fact, an action has been taken against the boat and is what you call an admiralty action against the boat itself. Because the incident happened on the boat. It was an activity, public activity taking place on the boat. So courts have what you call different, and the technical term you would hear jurisdiction. A court will have different jurisdictions. So, for example, if it's a divorce, that is dealt with in the family jurisdiction. If it is a constitutional matter, that will be dealt with under the constitutional jurisdiction of the court. If it's, in this case, is brought as an admiralty action, it's an action against the boat. So the boat has been arrested in that action. It can be open now, just as you apply for bail for an individual, somebody who is charged with an offense, you apply for bail, then it is open to apply for bail for the boat. And again, the reason, now, it's a different context when you speak of bail, a bail for boats, for example, and the arrest of boat. The boat is not a human being. So, for example, in the criminal matter, a person is arrested and charged. The next issue is, should that person be granted bail, or should that person be remanded in custody pending the hearing and determination of the matter? And the prosecution may not object to bail, in which case the magistrate can just grant bail over the phone because there is no objection.
But if the boat is arrested and the boat could be granted bail, could the boat be also looked at as bail could be denied because it could possibly be a flight risk? Because those same standards is used individual.
But flight risks again in a different context, because an action is brought against the boat. Remember, the boat is not registered in Grenada. The boat is not a Grenada boat.
Right.
That boat can sail away tomorrow.
Yes.
If, for example, then Anderson Peters, the civil claim is determined. All the Trinidadians are back in Trinidad.
Yeah.
And the boat is in Trinidad. There's nothing to enforce any judgment against.
Right.
Because everybody could go in Trinidad, back to Trinidad, not put in a defense. You could get a judgment and it ends up as a paper judgment because you have nothing to enforce against. And in the civil matter, the boat being arrested is in the context of that. So, for example, there's all, these different concepts, security for cost. I suppose what any negotiation that will take place, part of it, if the boat is to be released, then a court and the other side would want to be assured that if we get a judgment, how do we enforce it?
Right.
And there are different ways to do that. Monies can be paid into court, different ways. But it all depends on the circumstances. I'm just simply saying what, from a procedural standpoint, what can be done, and the reason for arresting the boat. The reason for arresting the individuals is because there was a criminal charge pending against them. The reason for arresting the boat, however, is to ensure that in the context of a civil claim, and that's why a civil claim was brought before the arrest of the boat. It wasn't just arresting the boat. So you actually file a civil claim in the court and you say, listen, court, we have a civil claim here. If we get judgment in our favor, these are non-nationals. How do we get our judgment enforced?
Right.
If the court awards X, how do we get X? So all of these factors. So it's in that context that the boat is seized. But then there are several other factors, maybe too confusing to explain in a short period of time.
Right.
But the boat can apply for bail for the boat, that as one can apply for bail for an individual. And a court would determine whether or not bail should be granted if satisfied that there is some alternative in the event that there is a judgment, that one can enforce the judgment against the boat. Very important information there.
Ruggles, the fact that the criminal case went before the civil case, right? The men they pleaded guilty. Does that reinforce and strengthen the civil case now against these men? Because they already claim liability. Does that make Sylvester's job even easier? Because, hey, I don't have to prove your guilt already. Again, you already plead guilty for this, so you're guilty for this. Does that make his job a little bit easier?
It does, because it was a guilty plea. It does because remember, a civil trial is a different trial. This matter was dealt with in the magistrate's court. This admiralty claim, however, will be dealt with in the High Court. It's just as though there is like a motor vehicle accident.
Right.
The driver is charged for driving without due care and attention. And he's found guilty. However, a civil claim is brought against him. And he may have been found not guilty. A civil claim can still be brought against him. And the court will now determine whether in the civil matter he's liable or not. Right. But having pleaded guilty, and generally you can't use what goes on in the magistrate's court in the criminal matter as evidence in the civil matter. However, having pleaded guilty and then accepted liability, then that can be used as evidence in the High Court.
In the High Court, yeah. I was thinking that. Guys, again, we open up the phone lines if you want to chime in. The number that you call in is 718-701-5720. That's 718-701-5720. On another note, Mr. Ferguson, we have this particular case. It took like about 1 week. It seemed as if it was just everything stopped. And this case was able to just go through the court. But we already know that there are many other cases that are supposed to be processed that on hold, that was pushed back. Why did this case get priority in the court?
Okay, in this case, first of all, it was a criminal case, and the individuals, when brought to court, pleaded guilty on the first day they were brought to court. So there was no need for a trial. All that was needed was the sentencing, which the magistrate did within 48 hours. So, however, if there was a not guilty plea, then what you would have, the prosecution will have to disclose the evidence and you have a trial. How many witnesses you have? It would have gone on longer. So cases could be completed within a day in criminal matters. Not a High Court civil matter, because there are procedures unless it is settled and there's a consent order among the parties. In a criminal matter, and in this case, the folks were in custody. The folks are not from Grenada, and therefore they had to be brought to court at the earliest opportunity. So, for example, if let us just say, in this case, the prosecution was not objecting to bail.
Right.
And so the accused persons were released the same night or the day after they were arrested. Then a date would have been given somewhere down the line, maybe October, based on the schedule of the court, to be brought to court, for them to be brought to court, for the matter to be addressed. However, once the prosecution is objecting to bail, then an accused person, any accused person, has to be brought to court at the earliest opportunity. Because you can't keep them in the station.
Right.
And the police can't send them in Richmond Hill Prison and say, well, okay, we're objecting to bail. The decision whether to grant bail or not lies with the magistrate. The prosecution may not object to bail, and therefore the person is released on bail. But once there's an objection to bail, so this incident took place on X day, the earliest date to bring them to court, then they were required to be brought to court, because then they will have an opportunity to make a bail application.
Right.
However, they chose to plead guilty. So, in a sense, having pleaded guilty, there was no need to consider the question of bail pending trial, because there would be no trial. The only issue would be sentencing. And it's a summary matter, so it was dealt with that way.
Right.
What takes time in the court is when there are trials, because an accused is not pleading guilty, is contesting the charge, and evidence has to be taken.
So, and I think we need to echo that, because a lot of people were saying that this case got preferential treatment because of who was involved. You're saying if X, A, and B individual committed a crime on Monday, they committed the same crime on Monday. A is a big time celebrity or someone that is very well known, and B is just someone that is not very well known at all. The court don't take priority in terms of the person themselves. Instead, the earliest convenient date, that's when the court will hear both of the cases.
Well, yes, but there may be circumstances where one says, listen, we are asking the court to expedite this matter, especially, let's say if the Trinidadians all pleaded not guilty, and they were remanded in custody, then, and is a summary charge, then courts in their own discretion can seek to expedite these matters, especially because it's a summary matter.
Yes.
So you would hear in instances, Trinidad, Jamaica, several of these countries where people are in prison, in custody, on remand, pending their trial, and they end up staying on remand for 10 plus years, for more time than if they were to if they were convicted of the offense. So what you try to do, a court in managing its docket or the matters before it has wide discretion to say, well, listen, this is a matter we should seek to try to dispose of. There's several factors involved, and therefore you put it on a priority list. But it depends on several factors, because a court always seeks to clear as many matters on its list as possible, and if an opportunity presents itself to do so, then a court would do so. But it does not necessarily mean because it's X or Y involved that then it's preferential treatment per se.
Right. I think that is very important that people understand that. In fact, the whole discussion I think is important and very timely because they would let the viewers have a broader appreciation for the decision that was handed down, the reason for the decision, the time frame for the decision, and the civil case versus the criminal case. Now, the civil case has not yet been finalized. The
It's still
conclusion
pending.
is still pending. The conclusion of the criminal case doesn't mean that means the conclusion of the civil case. Tomorrow, the next day, whatever, you may well see return to court in the civil matter, where the Derek Sylvester is the lawyer representing for Anderson, and this is for claim for damages, and that would determine if we see a release of the seizure notice that's on the boat, and the boat could leave and go depending on what the decision is from the civil case. So it's very important to understand the differentiation between these two cases. I think we did very well. I think you did very well. Sorry, I just learning. You did very well in explaining because we don't even have much questions. Somebody called, and I guess they got all the clarification, and you did so well that we don't even have a call. I think you did excellent, Mr. Ferguson.
Well, thank you. It's important to, you see, there are a lot of little fine things because I remember in the in one of the reports that there was a report of the individuals being brought to the High Court, for example, and the High Court is a different court. That is the Magistrates Court, and why the Magistrates Court? Because it was a summary charge. And even though it's an indictable or more serious charge, even indictable matters, the magistrate here is what you call a preliminary inquiry.
Right.
Unless the accused agrees to a paper committal and therefore you have no inquiry, you just have a paper committal and it goes up without the witnesses having to go in the box. You use their statements.
Yes.
Then the magistrate will have to conduct something similar to a trial. But it is not, the magistrate does not have the authority at the end of it to find the person guilty or not guilty because it's an indictable matter. The authority of the magistrate in those circumstances is to determine whether sufficient evidence has been adduced at the preliminary inquiry.
Yes.
To make out a case for the accused to answer in the High Court.
Yes.
If a case is not made out, the magistrate has the authority to discharge the accused. If a case is made out, the magistrate cannot determine guilty or not guilty, then all the magistrate has to do is to send it to the High Court for determination now before trial and jury.
Absolutely. I listen, I can't think of any other question. I think we went through the whole list of things that people was asking. Of course, if we give everyone 2 more minutes, if you want to call in, this is your final opportunity to call. The number is on the screen, 718-701-5720. And again, this whole conversation was prompted because there was so much misinformation that was shared on social media in regards to this particular post, involved in the legal sense, and not what happened, not who said this and who saw this, in terms of the legal conversation, what is happening now. So we now understand, guys, there are two cases that we're talking about: the civil case and the criminal case. The criminal case just concluded. The 4 men was found guilty. They were charged
They pleaded guilty. Yes.
They pleaded guilty. Pleaded guilty, was sentenced. There was to pay $5,500, and that funds that doesn't go to Anderson; it goes to the state. That was another question that you guys was asking. Mr. Ferguson explained it right here. So again, we'll give you guys about 2 minutes. If you want to call and ask any further question, you could feel free to do so. But I think we covered a lot of grounds here today, Mr. Ferguson. Any last thing that you wanna put in there that you deem is important for audience?
Well, just to say that, again, public legal education is always important because there are so many technicalities and niceties in the legal system that would not be readily appreciated if not explained to the public. And it's important in this case, in these circumstances, very unfortunate, involving Peters, that the criminal matter is now determined, and that was determined in the magistrate's court. It's now over to the High Court, different rules and procedures to determine the civil claim against the boat. And that's why it's brought in what is called the Admiralty jurisdiction, because it's an action against the boat. You can take, in the Admiralty jurisdiction, you can take actions against the boat. Had it not been in the Admiralty jurisdiction, for example, the boat could not have been arrested. But the whole idea, when stripped of all its technicalities, what the civil claim would be determining is how much compensation should be awarded to Anderson Peters for the injuries he suffered arising from the incident. And the court now would have to apply its principles in compiling the compilation of damages, how much damages to award. So, for example, in his case, he's an athlete. He's not just an athlete, but a world-renowned athlete who is participating in he's in the middle of several international competitions, and where he is actually not just participating, but winning.
Yeah.
And so quite apart from the injury and compensation for the injuries, the bigger issue here is what was the direct result of those injuries. The fact that he could not compete in international competitions, and therefore that is where you have differences now. Somebody who just gets an injury in those circumstances, that could have been dealt with in the magistrate's court by the magistrate, the parties agreeing to some kind of compensation, and that will be the end. However, in this case, where you have an international star athlete, how he is affected both psychologically now and physically will be factors to be weighed in awarding damages.
Right. So and including
like a totally different ball game.
Including, embarrassment and how he felt, and all of these other factors would be played into the final numbers. So it basically it's a determination on many different factors.
Indeed.
Yeah.
And many different factors beyond the mere injury suffered.
Right.
Yeah. Hopefully those injuries are not of a permanent nature. Hopefully they are some transient or temporary nature where he is able to compete and do Grenada proud as soon as possible. Hopefully that is the case.
Yeah.
But those are considerations for the civil matter.
We got one last question here. Kibbs is asking, so are they allowed to leave Grenada with pending civil case?
Yeah, sure. Remember, the civil case is really against the boat. I know sometimes it's hard to grasp that concept. The civil case is against the boat itself because they are all what you call agents now. Agents. It was the boat cruise. It's a registered boat, and the injuries were sustained during the course of an activity on the boat. So the compensation is not really for the individuals now, it's for the boat itself and, of course, by extension, the owners of the boat.
Yeah. All right. Very clear. Thanks again, Mr. Ruggles Ferguson, for your very in-depth analysis and information on this case. I think we were very well served to the audience. Again, We'll keep in touch, Mr. Ferguson. Thanks again.
Sure. Thank you.
All right.
Take care.
All right. Bye-bye.
And good evening all.
All right. Nice. Yeah, so that was Mr. Ruggles Ferguson, guys. Can't get any better than that. In terms of the information, guys, I believe that they probably have any questions was said here today, because I think Mr. Ferguson was very, very clear about it. Again, this whole conversation was prompted because of some posts that was, a series of posts that was made, and I realized that people really didn't have a full in-depth understanding as to what's happening here in terms of the civil case and the criminal case, and I thought this was necessary. And hopefully going forward, we'll have a better, broader understanding of it. And again, I appreciate Mr. Ruggles Ferguson time. It was just about an hour ago we contacted him, and he decided to give us at least an hour to explain it in complete details. So from here, guys, the criminal case is completed. Going forward, we'll hear more information on the civil case. And that is basically against the boat and the owners of the boat. We'll hear Mr. Derek Sylvester possibly making appearances on this platform, other platforms, or speaking out about it, and you'll be like, but wait, no, I thought this case finished already. Yes, the criminal case is finished. The civil case now is in full effect, and they are suing for damages, right? They are suing for damages. So the $5,500 that was fine for in the criminal case, that has nothing to do with Anderson, right? That in fact doesn't even go to Anderson. That $5,500 per person that was charged, that goes to the state. All right, the civil case. That's what we're looking at now. The civil case. All right, the civil case. Okay, thank you, guys. I'd like to thank our sponsors and everyone who made it possible so we could be here today. Let's take a quick word from our sponsor. I'll come back with my closing thoughts. Don't move.
Grenadian products are now only a mouse click away at GrenadaMarket.com. Nutmeg and guava jams, jellies and the syrups, world famous nutmeg pain relief spray, black sage, soursop, lemongrass, and guavande bar. Ordering is simple and friendly. All major credit cards accepted. Safe, secure shopping guaranteed. GrenadaMarket.com ships your product anywhere in the world. So when you can't go to the island, the products off the island can be sent to you. Just log on to www.grenadamarket.com and experience our quick delivery and homely service.
Make this carnival a special one at Spice Isle Jewelry. Get up to 40% off our collection of silver and gold jewelry with purchases above $115. Visit our 2 locations on Grenville Street, St. George's and Spiceland Mall Grand Dance, and see our fine selection of traditional West Indian bangles, necklaces, earrings, rings, and our unique handmade pieces. Step into Spice Isle Jewelry and shop in air-conditioned comfort with friendly, helpful, and courteous staff. We also pay the most for scrap gold. Our repair service is second to none. Treat yourself or someone special with something special from Spice Isle Jewelry, serving you since 1986. Call us on telephone number 440-3155 or 440-6648. Sale ends August 31st.
Hi guys, once again, thank you. Don't forget, guys, if you want to advertise right here on Ridealong Live, you have a business and you want the whole world to know, your service and product or service or event that you having, give us a call. We have a special on for till the end of August, right? Where we have a 30% discount in advertising rate right here on Ridealong Live. So don't keep your business a secret. Advertise right here on Ridealong Live in this later part of August and send your business viral. All right, remember, it costs nothing to advertise. It pays to advertise. When you advertise, you get to reach hundreds and thousands of millions of viewers around the world. Inbox us or call us for more information on how you could take your business viral.
Also, guys, don't forget we having right here on Ride Along Live. We're going to be not on Ride Along Live, but Ride Along Live is going to be sponsoring our support group brunch, right? Our support group brunch right here in New York. So, want to see you guys there. We're going to have more information on it Labor Day weekend. So if you're going to be in New York, you got to be a part of the Ride Along Live support group brunch. Okay, oil long and ting, pale out and ting in full effect, cocoa tea, lambi waters, the list goes on. It could be real vibes. Ride Along Live support group brunch right here in New York, Labor Day weekend. More information we'll give you guys. And you could pre-order your oil long, you know. We'll give you the website, right? Starting Monday, you could pre-order your brunch, right? We have cocoa tea, oil dung, lambi waters, potato pudding, bakes and saltfish. Real thing, I'm telling you, real thing. Real thing. Real thing, real thing, real thing. It could be real vibes. Ride Along Live support group brunch. Yum, 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 yum. Lick all your fingers and things there. That's what we're talking about. Yes, it could be vibes, it could be vibes, it could be vibes. For more information, guys, you could also inbox us. Tomorrow! Yeah, planting and thing too, you know. All good stuff. Tomorrow, guys, is Free Up Friday. No drama on a Friday. And we're having the Ride Trivia, 6 p.m. Come on, play, man. It'll be real vibes, music and thing. No drama on a Friday, guys. Absolutely no drama on a Friday. That's tomorrow. Free Up Friday. Ride Trivia on a Friday. On behalf of all our crew here, our executive producer, Lois JJ, hardest working team member. Of course, our hardest working moderators, they work real hard. Lois, Lynn, big up yourself. Hey, big up to Kibbs, big up to Gail Charles, and also Deanne Fraser. Team Ride Along say good night. And the word for today, guys, be nice to somebody short. Because you never know when somebody short have to be nice to you. Yeah. Guys, this Sunday, Grenada Day in New York, and of course, Ariza will be in New York for the Grenada Day. Ariza Credit Union say hello New York, and they are coming. Yeah, so if you're looking to get your set up an account with Ariza, general inquiries, new membership, small deposit, you can check them out. You got to bring a Grenadian or CARICOM ID, passport or sign, and also a signed job letter or salary slip, US $100, proof of address, utility bill, or bank statement. Sign up with Ariza Credit Union. They're going to be in New York for Grenada Day. Yeah, looking to see you there. Hey, listen this. We have to have some fun for Labor Day, right? So, you know, we were in Grenada with Amazing Colors Monday Night Mass, right? Well, they're taking the whole jam to New York. We're taking the whole jam to New York, guys, for Labor Day. So it's all about Amazing Colors, the trilogy, New York City, right? More information coming soon, where you can get your packages to be on the road for Labor Day. Real vibes. Stay tuned to this platform for more information. So if you ain't going to be in New York for Labor Day, we want you to play Monday Night Mass with, not Monday Night Mass, guys. Play Mass with us on the road. We're going to be teaming up. We're going to tell you about the band we're going to be teaming up with. All the information, guys, coming soon. It's Amazing Colors Trilogy package for Labor Day. Good night, guys. Catch you guys tomorrow. Bye-bye. Well, it's on the Ride Along, so it's happening here.
Came over here. What does it mean? You know, I grew up in what I guess we call a typical family.
We break all the stories, and that's just a fact. And that's why everyone has a story to tell.
Ridealong Live, I mean, yeah, it's the real deal.